Good morning, everyone. Welcome to our webinar today on buying a tech or online business, what you should know. My name is Anthony. I'm the co-head of legal here at LegalVision UK, also a practice leader in the corporate and commercial team specializing in mergers and acquisitions. Now, before we begin our webinar today, just a couple of housekeeping items. You'll receive a recording of today's webinar and the slides in an email afterwards. You can submit questions throughout the webinar in our Q&A box, and I'll do my best to answer them at the end of the webinar. And we'd kindly ask you to please complete the feedback survey that occurs at the end of the webinar. Also, for the next 48 hours, you're eligible to receive a free legal consultation with LegalVision to just discuss how we can potentially help your business. So please provide your contact details in the survey at the end of the webinar. So today, we'll be discussing some key issues that you as a buyer should be thinking about when buying a tech business or an online business. Maybe you're looking to purchase a software business or a software as a service business, or an IT support service business, or maybe just an e-commerce business that sells various goods and products, potentially through a drop filling model. And in all cases, today's webinar is to try and illuminate some basically key issues that you should be thinking about before making that acquisition. So we'll be going over just generally, the deal structure of whether you do an asset or a share sale, thinking about your term sheets or heads of agreements, thinking about due diligence, speaking about how you can structure the purchase price and potentially some security that a seller might want a view of that. Discussing conditions precedent, the conditions that are required to complete a deal, and then kind of going into three areas that are pretty key when negotiating the relevant purchase agreement, which is warranties, indemnities, and restraints. To kick off, though, our webinar, we do have a little bit of a poll question for everyone in attendance. And the question is, what's your main focus when considering buying a tech or online business? It's a multiple choice answer, and you can choose two options. So I'll give you a moment now to answer the question. Just wait for them to come through. Great. Thank you all for answering. Interesting results. Everybody pretty much said finding the best deal structure as being the most the main focus, with second being negotiating for favorable terms, and then third, understanding due diligence requirements. So that's really great. These are kind of all things that we'll be touching on in today's webinar. Okay, so I mean, first of all, before we kind of dive into everything, it's always good to get a good understanding of what's generally the process that's involved in undertaking an acquisition. First and foremost, I would always say make sure you're engaging a lawyer that knows what they're doing to help you guide you through the process. But generally, the flow in a deal is an initial sharing of some maybe information for you as a buyer, and you requiring to be signing an NDA or a confidentiality agreement. The parties will then kind of move over to signing a term sheet or a heads of agreement. You'll then, as the buyer, undertake some due diligence. The parties will then negotiate, usually at the same time, the relevant sale purchase agreements. Parties will then finalize their deeds, sign the documents, and then move to completing the deal. You pay them, and there's various other completion obligations that occur. So on the next slide, though, we dive into our first topic, which is what's the best structure, or what's the first way that you structure the deal, or your acquisition. And you've got two options. There's either an asset sale, where you as a buyer are simply buying all of the assets of that business from the relevant seller. Or alternatively, you are undertaking what's known as a share sale or share purchase. So you acquiring all of the shares in the company that is operating that particular business. Now, both have their pluses and minuses, disadvantages and advantages. I think from the perspective of an asset sale, there's definitely more administrative steps that you would have to deal with, in terms of dealing with assignments of key contracts and dealing with 2P, unfortunately, transfers of lease and transfers of IP. But generally, it's considered a lot less riskier for buyers because you get to really cherry pick which assets of the business you want, and you don't have to worry about taking over the historical liabilities of that particular business. Versus a share purchase acquisition, there's generally a lot less due diligence, and it's generally a better tax outcome for you as a purchaser versus the seller. It's a little bit of a less tax efficient option. With share sales, I guess the positive is, or share purchases, that there is, I guess, less administrative steps for you as the buyer, because you're kind of taking the company as is, and the company just simply, or the target company simply just continues on. You don't need to worry about dealing with 2P. However, there is a lot more risk, I guess, in acquiring a target company because you are basically taking on all the historical liabilities that particular target company has accrued over time. So, that generally means you need to do a little bit more DD to kind of find out all the skeletons in the closet, as it were, of that particular target company, which generally means that there's probably a heavier negotiation in the purchase agreement around warranties and indemnities. And generally, when you're trying to negotiate these deals with sellers, the sellers will usually try and go more the share sale route because it's more tax efficient for them. Then on the next slide, one of the key things that you'll be doing in the deal is initially entering into a term sheet, also known as a heads of agreement. This is a largely legally non-binding document, but it's quite useful because it gets the parties really thinking about the key commercial terms, mainly around, for example, how the purchase price is going to be structured, maybe what completion obligations you're expecting of the parties, certain conditions that people or the parties are expecting. So it just gets everyone really focused and aligned on kind of day one, which then sets the basis for ongoing negotiations then for the purchase agreements. Whilst it is largely non-buying, I think that the real big thing for buyers is making sure that you are including a binding exclusivity period clause. And so what that type of a clause does is make sure that the seller and the target company can't go off and start negotiating with other people to try and sell the business or sell all of the shares. You've got exclusive rights for a period of time, and that period of time is usually between 3 to 6 months. One of the other things that I often advise clients also to try and get up on is also including some sort of a break fee or an indemnity on costs. And that could range anywhere between £5,000 to £10,000, for example. And the reason you want to ask for that is basically twofold. One, to make sure that the seller doesn't breach their exclusivity period clause. And secondly, the reality is if you're engaging accountants and lawyers to help you with the buying process, it's you're incurring costs, and having that break fee, if they were to breach their exclusivity clause, at least that money is going towards covering those sunken costs that you've absorbed. Then, as buyers, another key consideration is due diligence, and for me, this is definitely, I think, one of the biggest and most important things that you can be doing as buyers. Mainly because it influences so many other aspects of your acquisition process. Now, due diligence, in essence, is basically the process of kind of investigating the target business or the target company, and it's really about making sure that you as a buyer are making an informed decision on the business that you're about to acquire, making sure that you're knowing what you're paying for. It's validating a means of validating the purchase price that the seller is asking for, and potentially any earn-out mechanisms. And importantly, it's a way of after doing that investigation and audit, highlighting key issues which either you need to deal within the purchase agreement itself, either through warranties, or completion obligations, or indemnities, or maybe you're discovering issues that create a walkaway position for you, and simply doesn't make the deal as valuable, or in essence, just basically wanting to be able to move on from that deal because it wasn't what you thought it was stacked up to be as a business. Now, I think as a tech and online business, I think arguably the most important asset that they have is intellectual property. Now, on the next slide, I've kind of set out just the various areas that due diligence touches on. So you would be doing investigations on naturally their financial position, employees, corporate governance, any historical claims and disputes, plant and equipment. But what I thought would be helpful for everyone is this should delve into a little bit into three key areas. So on the next slide, I think, as I was just saying, I think one of the key areas of due diligence is intellectual property because of the nature of tech and online businesses and it being arguably the most valuable of assets. So the questions that you're kind of asking yourself in this particular phase of due diligence for this particular area there's a multitude. I think one of the biggest ones is, does the target business actually own the intellectual property that's being developed? Does it own that software that it's created, or the platform that it's created? So often I see clients who are new to business. They aren't developers themselves. They've just got this really great idea for a SaaS platform, and they go off and get that developed, by a third party. But, you as a buyer, the question is, well, has that third party developer assigned over the intellectual property in what they've developed over to the target company? Or maybe it's the case that the founders themselves, originally were in the tech space and developed the particular app. Again, is there documentation showing that those founders have assigned over that IP to the target company? And that could maybe be in the form of an employment agreement or some sort of separate IP assignment deed. Also questioning, again, like if you're in the space of software, how much of the platform or how much of the software is reliant upon open source code, which, if it's heavily reliant on open source code, then that's probably not necessarily a great thing. Do you necessarily have that unique of a product that you're about to splash the cash on? Analyzing how reliant the particular platform is on third-party software, third-party plugins, and then kind of analyzing the terms and conditions and the that are attached to those third-party licenses. The particular tech, business or online business will naturally have a brand. So asking, what type of protections that brand has. So are there registered trademarks, or should they be registered? Also kind of, asking to what extent, are there other players out there that are potentially infringing the seller's IP, but almost more importantly, has there been any historical claims from third parties saying that that tech infringes their IP? And if there is, then that, for example, might be something that you need to cover off as a specific indemnity in the purchase agreement, or maybe it's so serious of a potential infringement claim that that sets the basis of you walking away, or potentially, reducing the price that's being negotiated. Another kind of key area in due diligence, on the next slide, is thinking about key contracts and material contracts. And again, for tech and online businesses, there might be relationships with third-party suppliers that are really key to the continued operation of the business. So one of them is, as I mentioned, intellectual property licenses with third parties. It could be, relationships with third-party payment providers. It could be the particular business being reliant on a third-party developer or third-party hosting providers, or third-party support and maintenance providers, particularly if the business is a little bit smaller, it doesn't necessarily have its own in-house team of developers and tech people, and then reliant on these third parties to provide those services. If it's an online business that's selling goods, or unique goods, then you really need to dive into, well, what are the agreements in place with distributors or key manufacturers, both locally and overseas. If there was a drop shipping style model online business, then having to look at what were the terms and conditions are of the fulfillment center contracts that may have been entered into. Whilst I realize that most of the time online businesses and tech businesses these days might be operating on a kind of remote basis, there are still businesses out there that do have a physical premises. So there is a need to also be considering potential property leases or licenses. Now, when we're reviewing those type of contracts, it's important to be thinking about, do those agreements contain potentially onerous or non-market standard terms? What are the termination rights that other parties have or that you have in those agreements? What are the assignment provisions look like? Are there any change of control provisions in there? And then generally making an assessment of the commercial terms of those contracts. And then lastly, I think another key area in due diligence in this day and age, particularly in the UK, is looking at privacy and compliance around privacy laws, which is on the next slide. So much of the tech and online businesses is very much dependent on collecting personal data, and it's quite an important area from the perspective of the potential penalties and ramifications of not complying. So it's a definite risk in this particular the tech and online space. So it would be, incumbent on you as a buyer to be assessing what policies the particular target business has in place. Has there been any historical privacy breach events or incidents or complaints? And then really doing an assessment of what security measures are in place. So that might even be in the form of, assessing what penetration testing has historically been done on the software to see what type of ongoing risk there might be for a privacy breach. On the next slide, another kind of area that you as a buyer of this particular type of business is asking is the purchase price. And I think the first question you need to be asking yourself is the purchase price that the seller asking for, is that right? And a lot of that will come down to you undertaking your own valuation of the business. And that might require you to go off and, speak to your own accountant or engage the services of a third party valuer to properly value the business. You're also asking yourself, well, how am I going to fund this business, the acquisition of this particular business? Now that might come from your own money or investments, or you might be having to go off to third-party financiers to obtain a loan, or you could be asking for the vendor themselves or the seller themselves to be basically providing vendor finance, which largely it looks like a deferred purchase price consideration, although sometimes sellers will ask for that deferred consideration to kind of have interest that is payable on it, sometimes not. Other considerations on the purchase price are, particularly if you're operating or they are operating an online business that has stock that might be stored in a third-party warehouse. Is the stock included in the purchase price? If you're doing a share sale, is that being done on a cash-free, debt-free basis? So in essence, on day one, you're expecting the company to be a little bit clean, no cash in the company, no debts at the same time. Or potentially the alternative is that there will be a certain amount of cash and liabilities, and the parties are negotiating some sort of working capital adjustment, and you're expecting that there's going to be a certain amount of working capital in the business so that you can continue to operate that business from day one. Now, as buyers, it's really hard to be having to splash the cash all up front. And so generally as a buyer, I think you are wanting to try and defer a little bit of the purchase price consideration. So that might be, trying to agree with the seller that 50% of the purchase price is being maybe paid 6 months from now or 12 months from now, and to try and mitigate the risk of you potentially buying a business that you're not 100% sure is going to perform the way you expect it to perform. You could be linking that deferred consideration to either certain KPIs. So that could be sales targets that the business needs to achieve, or profit or EBITDA targets, and it does protect you in that way. And you could be negotiating that either on an all or nothing basis. So if those targets aren't met by the business, then the seller doesn't get any of that deferred consideration, or maybe there's some sliding scale pro rata approach that you take so that you're paying less in essence if the business doesn't perform the way that the sellers were representing or forecasting it to perform. I think part of the deferred consideration point is that sellers will try and secure that deferred consideration, which is pretty market standard. I would say as a buyer, do your best to push back on having to give any personal guarantee. However, it would be normal for a seller to be asking potentially for some sort of charge over shares or a debenture, which is in essence a charge over all of the assets of a person or a company. And then alternatively, another point to be considering is maybe you're structuring the deal. Maybe you're already a tech business or already operating an online business, and you're looking to grow inorganically by doing acquisitions. So maybe part of your strategy is partly paying in cash, and maybe partly paying founders or sellers in shares in your own company. In which case, then you need to start thinking about, well, what are the type of shares I'm actually giving these people, and having to negotiate shareholders agreements and articles of association, and what rights and responsibilities those founders will have as part of your company. On the next slide, one of the key considerations in negotiating the purchase agreement are the conditions to completion. Now, basically, what these are things that, if they don't occur, the parties get to walk away from the deal, kind of no liabilities, no strings attached, other than usually just repaying a deposit if there has been a deposit that's been paid. And most of the conditions in purchase agreements are for the benefit of you as a buyer. So if they don't happen by a particular date, then you've got the option to just go, okay, the deal's off, walking away from this. So some of the conditions that you as a buyer might be looking for is, kind of harking back to things that you have found during due diligence. So it could be that a key fulfillment provider needs to enter into a brand new contract with you on terms acceptable to you, or that a third party software provider that's a key integral part of your software, again, needs to enter a brand new contract with you, or needs to vary some of the terms and conditions, and needs to consent to the assignment of that contract to you. It could be making sure that founders, have signed the right IP assignment deeds over. It could be that, in your assessment of looking at the employee base of the particular target company or target business, you discover that actually, wow, there's all these key customers that make up so much of the sales. Maybe it's a government contract, and again, making sure that if those contracts need to be assigned over to you to obviously to ensure that your sales aren't affected. Or it could be that you find out that there's these key employees, like maybe a key website developer, or key platform developer, or key salesperson, that is so crucial to the ongoing needs of the business that you want certainty that those people are going to continue on with you. On the next slide, then, kind of another area in the purchase agreement that is hotly contested between the parties, and again, this is where your lawyers, who hopefully know what they're doing, are able to guide you, are warranties. So a warranty is basically a promise about a contractual promise about the state of the business or company that you're looking to acquire. So it will cover things like that the business has complied with material laws and employment agreements, that there isn't any third-party IP claims, that there hasn't been any privacy breaches, that there is no current or pending litigation against the business. As a buyer, you really want a comprehensive set of warranties in the purchase agreement in order to protect you. And that protection comes from the perspective of, if the seller was to breach those warranties, then at least you've got a claim against them for the damages that you've suffered. Now, it's important to always try and negotiate that those warranties are given not only at the time that you enter into the contract, but also at the time of completing the deal as well. Normally, it's the case that sellers will disclose against those warranties. So they'll tell you during due diligence, maybe there is a particular ongoing claim with an employee, and they'll specifically disclose that. Generally, as a buyer, you only want to make sure that the warranties are disclosed against specifically things that have either been put in the data room or put in the specific disclosure letter that sellers will usually provide you as part of the transaction. Now, generally, sellers will try and do their best, and their lawyers will try and do their best to limit their overall liability to you. Generally, market standard is that they'll try to put a cap on breach of warranty claims to the purchase price, which is generally acceptable. But they will try and do other little things to lessen their risk and their liability to you. So, for example, in warranties, they'll try and qualify a lot of warranties by the words "so far as they're aware." So you can always try and push back on things that you know they shouldn't be qualifying with those words. Sometimes they'll try and exclude out indirect or consequential loss, which is usually linked with loss of profits or loss of data or loss of opportunity. And for me as a buyer, that they're the type of losses that you're most likely going to incur as a result of a breach of warranty. So definitely be trying to push back on that. They will try to put some time limitations on claims, which is generally market standard. So generally, you're looking at being accepting anywhere between 2 to 3 years, but it does depend on the deal size. As buyers, however, I would say that you're always trying to exclude out any time limitation on any fundamental warranty that goes to title. And also making sure that you're getting at least 7 years on any tax warranties and tax claims. And generally, you try to, the seller will try and put in a bunch of exclusions in the purchase agreement, or sorry, caps on liabilities. Generally, you try and want to exclude out anything that they do on a fraud or willful concealment perspective. The other consideration as a buyer is, talking about potential breach of warranty claims and claiming back damages. I think one of the things that people very easily forget is, well, what happens if you're buying a business from a seller or buying shares from a seller that is a company. Once they sell all of those assets, then is it likely that company actually doesn't own any other assets? So if you did have to bring a breach of warranty claim, then you're potentially you're potentially suing an entity that has no assets. So you could be thinking about getting some guarantees from the other side, either as some sort of personal guarantee by the owner of that company, or a guarantee from some separate company that does have assets. And I would also say that one of the things that as a buyer you always want to try and do is that if there is deferred consideration, then ensuring that the purchase agreement has some set-off rights, so that if there is a claim, you can kind of set that off against any deferred purchase price. That kind of segues into the indemnity issue, which is on the next slide. And what is an indemnity? An indemnity is basically a contractual promise from the seller to pay you, specific damages or losses that you incur as a result of a particular issue or action that they do. And that's advantageous to you as a buyer because you don't have to go and prove your loss. It's usually paid on a pound for pound basis. And it's basically a direct right of payment of loss. It's a faster route to compensation versus having to go and commence a claim in proving your loss at court. Now, generally, it is a little difficult in the UK to get a broad indemnity for any breach of warranty. However, I have seen them given. So you're always, as a buyer, it's always worth having a shot at getting it. But definitely what we do see is, and what you should be covering off as buyers is, getting specific indemnities for specific identified risks. So again, in the context of what we're talking about, let's say that you've realized that there was a historical claim for the tech business on a GDPR non-compliance, or maybe there was a breach event, or a breach event that's kind of recently happened. So you would try and cover off a specific indemnity to cover off that risk, so that if there's any further ongoing loss that happens after completion, then it's on the shoulders of the sellers to have to pay you any loss that you suffer as a result of that particular risk. And then lastly, another key area as a buyer we want to cover off are restraints. And for me, this is kind of a non-negotiable as a buyer. Obviously, you're spending all of this money. You're wanting to make sure that you want to protect the goodwill of the business. So it's really important to make sure that the people that are selling you the business and and certain other key people that are selling in the business are restrained from setting up a competing business with you right after you complete, or poaching your customers and poaching staff and key suppliers. Now, generally, again, depending on the deal size, you'll see those restraints apply for about 2 to 3 years, and they also might vary in terms of how restrictive they are in area size. So it could be for the whole of the UK, or maybe it could be for a smaller area, or it could cover multiple countries. It simply depends on the particular business and where they're selling. And I would say that generally restraints are considered unenforceable. However, in the space of purchase agreements, generally the courts do enforce them because there's a lot of money that's being paid, there's consideration that's being paid. So, as long as they're not too extravagant and too unreasonable, they're generally going to be upheld. So it's a really good protection for you as a buyer. That actually concludes our webinar today. There is a free download. You can scan the QR code. It's basically a guide on buying a business in the UK, and a guide on negotiating terms. So a really helpful resource that I'd recommend you downloading. We also have an upcoming event that you might all be interested in attending. It's about how the new digital and consumer laws impact your business on the 25th of February. And you can register now by just jumping on to the link that's there on the slide. Now, I'm going to answer some questions that have popped up during the webinar and pre-submitted in the webinar in a moment. But before I do that, I thought I would quickly canvass over to you a little bit about LegalVision. Now, becoming a member of LegalVision, your business, in essence, gets unlimited access to our full team of over 100 specialist lawyers in various jurisdictions for all your business and as usual legal needs. And in essence, it's kind of like having your own in-house lawyer. And our team can assist with unlimited drafting of contracts. You get unlimited legal advice consultations and unlimited domestic trademark registrations. So as a LegalVision member, you don't really have to worry about the costs of lawyers ever again. Thinking about it in the sense of having your own little in-house team of lawyers. And if you are an in-house counsel attending this webinar, we actually do offer a dedicated service to manage higher volume businesses that you might be involved in. Now, to learn more about our membership or our desk extension option, feel free to request the free consultation at the end of the webinar. So a couple of questions that have come through that I thought I would answer now. One of them was, when looking to buy a tech or online business, where should I start my search? Now, look, I would say that there are brokers out there that potentially you could engage to assist you. There also are some websites out there where people voluntarily post up their own businesses for sale. So I think certainly they're probably the most relevant starting points if you're not able to kind of find an opportunity outside of personal networks. Another question was, what sort of agreements apply in the data context? I think that kind of goes back to my point around doing your due diligence in the privacy GDPR compliance space. So I think on the data front, it'll be about assessing whether the business has proper data processing addendums, and just generally other contracts that the targets have maybe entered into with clients or suppliers that contain relevant privacy clauses. And then I think the final question I'll answer before we head off was, what's one of the biggest commercial issues you find in buying an online business? I think that's a really good question. Um, I think as a commercial issue, I think probably one of the biggest issues is knowing, really testing the product that you're about to buy, the brand that you're about to buy. So getting a really good sense during due diligence about how unique the offering is of that SaaS product versus what's out there in the marketplace. And I think, assessing that by whether that's backed by the financial performance of the product over historically, because I think sellers overestimate the value of their brand, and that's why it's important during that due diligence phase, not only to be doing the legal due diligence but also the commercial due diligence and really understanding what you're about to buy. Okay, well, I mean, that actually concludes our oh, actually, no, I'll ask one more questions. There's two more I'll answer. When SPAs lead to disputes in court on what are claims usually based and what are the key lessons learnt? I think to answer that one, that is it's the SPAs, the disputes are usually around breach of warranty claims, initiated by buyers against the sellers, because in essence the sellers have misled buyers and kind of made representations during the due diligence phase or prior to completion about the state of affairs of business, which the buyer subsequently finds out about and then is able to refer back to the share purchase agreement and bring a claim for a breach of contract. And I guess arguably also the restraints provisions. There are instances where sellers or founders of the sellers go off and start a competing business when they shouldn't have. So I think the key lesson there is making sure that your share purchase agreement and business purchase agreement always includes those type of provisions to protect yourself as a buyer. Um, and then one other question: does LegalVision help out with due diligence as well? Yes, we do. I mean, from a legal perspective, we do assist with the legal part of the due diligence. Assessing with uh, sending out questionnaires to the other side on legal related issues, and then analyzing their answers and analyzing the documents that they upload to the data room. Okay, well, I will leave it there. Thank you, everybody, for your time today and for attending. If we haven't answered any of your questions, by all means, please send through, contact us, and happy to kind of field any other questions that you might have. As I said earlier in the seminar, submit your details at the end submit your details in the survey at the end, and to learn a little bit more about our membership and the free consultation. Thank you again so much for joining, and I hope you enjoy the rest of your day.